The two additional protocols to the 1949 Geneva Conventions were adopted by consensus at the 1974 to 1977 Diplomatic Conference on the reaffirmation and development of international humanitarian law applicable in armed conflicts. They emerged out of concerns that modern developments in weaponry, including weapons capable of inflicting massive casualties and extensive and long-term damage to state infrastructure and the natural environment, call for the adoption of new rules of conduct applicable to armed conflict. The additional protocols are also known as the optional protocols. The protocols have not conventions, and unlike many of the principles of the conventions, legal scholars do not consider them to constitute norms of customary international law. Protocol 1 pertains to protection of civilians and military civilian medical personnel during international armed conflicts. It expands upon the provisions of the original conventions and includes limitations and explicit discussion of the methods of warfare, its effect on the civilian population, and protection of civilians. One controversial aspect of Additional Protocol 1 relates to wars of national liberation. Article 1, Clause 4 of the Protocol includes as international those armed conflicts in which people are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. This represents a departure from traditional definitions of international as opposed to non-international armed conflicts by including a classification based on the cause for which one of the parties is fighting. Article 1, Clause 4 raised the concern for several states, including United States of America, India, and Pakistan, that the expanded definition could give cover to terrorist groups, an anxiety exacerbated by the protocol's sympathetic treatment of irregular fighters. Part 2, consisting of Articles 8 to 34, develops the rules of the First and the Second Geneva Convention on Wounded, Sick and Shipwrecked. It extends the protection of the conventions to civilian medical personnel, equipment and supplies, and to civilian units and transports, and contains detailed provisions on medical transportation. Part 3 and several chapters of Part 4, Articles 35 to 60, deal with the conduct of hostilities, that is, questions which hitherto were regulated by the Hague Conventions of 1899 and 1907 and by customary international law. Their reaffirmation and development is important in view of the age of Hague Conventions and of the new states which had no part in their elaboration. Articles 43 and 44 give a new definition of armed forces and combatants. They contain a definition of military objectives and prohibition of attack on civilian persons and objects. Further, Articles 61 to 79 deal with the protection of civil defense organization, relief actions, and the treatment of persons in the power of a party to a conflict. Part 5, Articles 80 to 91 brings some new elements to the problem of the execution of the Convention and the Protocol. Article 1 of the Protocol 1 provides the following general principles. Number 1. The high contracting parties have to ensure respect for this protocol in all circumstances. Number 2. In cases not covered by this protocol or by other international agreements, civilians and combatants remain under the protection and authority of the principles of international law derived from established custom, from the principles of humanity, and from the dictates of public conscience. Number 3. This protocol supplements the Geneva Conventions of 12 August 1949 for the protection of war victims and shall apply in the situations referred to in Article 2 common to those conventions. Number 4. The preceding situations include armed conflicts in which people are fighting against colonial domination and alien occupation and against racist regime in the exercise of their right of self-determination as enshrined in the Charter of the United Nations and the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations. The International Committee, working on the lines following after the 1914 to 1918 war, first collected the fullest possible preliminary information on those aspects of international law that require confirmation, enlargement, and amendment. In October 1945, the first meeting of the experts comprising of neutral members of the Mixed Medical Commissions, in brief MMC, was held. The members of the MMC had visited the wounded and sick prisoners of war during the conflict to decide about their repatriation. The preliminary conference of National Red Cross Society was held in July and August 1946 at Geneva. From April 14 to 26, 1947, the Conference of Government Experts for the Study of Conventions for the Protection of War Victims was held in Geneva. Protocol 2 is a 1977 amendment protocol to the Geneva Conventions relating to the protection of victims of non-international armed conflicts. Protocol 2 elaborates on the international humanitarian law principles relating to non-international armed conflict situation, providing an additional 28 principle set out in Common Article 3, although in specifying certain criteria, including a degree of organizational requirement for non-state parties. It defines certain international laws that strive to provide better protection for the victims of international armed conflicts that take place within the borders of a single country. The scope of these laws is more limited than those of the rest of the Geneva Conventions out of respect for sovereign rights and duties of national governments. Common Article 3 applies to the armed conflicts that are not of an international character, but that are contained within the boundaries of a single country. It provides limited protection to victims, including persons taking no active part in the hostilities should be treated humanly, including military personnel who have ceased to be active as a result of sickness, injury, or detention. The wounded and sick shall be collected and cared for. The extent of the scope of Common Article 3 in international law to cover additional humanitarian rights in the context of internal conflicts centered on two conflicting ideas. First, the distinction between internal and international armed conflict is artificial from the point of view of a victim. Humanitarian principles should apply regardless of the identity of the combatants. Second, international law doesn't apply to non-international situations. A nation has sovereignty within its borders and must not accept judgments and orders from other countries. The scope of this protocol is founded on the following factors. Number 1, material field of application. Article 1 of this protocol provides that this protocol develops land supplements. Article 3, common to the 4 Geneva Conventions of 1949, without modifying its existing conditions of application. It shall apply to all armed conflict which are not covered by Article 1 of the Protocol 1 additional to the Geneva Conventions of 1949. This protocol shall not apply to situations of internal disturbances and tensions, such as riots, isolated and sporadic acts of violence, and other acts of similar nature. Number 2, personal field of application. Article 2 of this protocol provides that this protocol shall be applied without any adverse distinction founded on race, color, sex, language, religion or belief, political or other opinion, national or social origin, wealth, birth or other status, or any other similar criteria to all persons affected by an armed conflict as defined in Article 1. Number 3, non-intervention. Article 3 of the protocol mandates that nothing in this protocol shall be invoked for the purpose of affecting the sovereignty of a state or responsibility of the government by all legitimate means. This shall also not be invoked as justification for intervening directly or indirectly in the armed conflict as such. This protocol simply aids the red diamond as an additional valid international symbol of ICRC. The valid symbols of the ICRC are the Red Cross, Red Crescent, and now the red diamond. Protocol additional to the Geneva Convention number 3 refers to this additional emblem as the third protocol emblem. The fundamental principle on which the law of armed conflict based is expressed as follows. Number 1, the first prohibits the use of weapons, projectiles, and material and matters of warfare of a nature to cause unnecessary injury. Number 2, the second, in order to ensure respect and protection for the civilians' population and civilian property, obliges the parties to the conflict to distinguish at all times between the civilian population and the military objectives, and to direct their operations only against military objectives.